let me just say, regarding this item, Mr. Chairman, this has been one of those items that probably I've gotten a few more phone calls on. We've had a little more discussion about. You know, I was privileged to be elected chairman back in December, and was given the charge and told about the raucous. You've certainly been gracious to me as chairman, and have overlooked some of my mistakes when I was potentially out of order a little bit there on occasion. It's been a learning process, and I do appreciate your patience. I would just say, as we approach this issue, because we've got some differences of opinion, staff-wise and board-wise, and our planning board-wise, with regard to the staff, that we discuss this on the merits of the issue. And let's be kind to each other and civil. How's that? We have a petition, rezoning petition for BOVA Corporation, and I will move to approve that petition. Ask for discussion. Yeah. Discussion. Tracy?
This is kind of right up my alley because this is what I do for a living. Legal analysis of this kind of thing, and it's my understanding, and I'm sure Mr. Crook will correct me if I'm wrong. But according to the School of Government's book, Legislative Zoning Decisions, which I do have with me, when looking at a rezoning that could be considered spot zoning, which I don't think anybody up here is going to argue that it is spot zoning. Not all spot zoning is illegal. But it certainly is a piece of land that is surrounded by land that is not the same zoning. So by definition, if you look at it, it's a spot zoning of a piece of property. And when that happens, there's got to be an affirmative showing of a reasonable basis for that spot zoning, which is why there's a statement in our packets if you're going to approve a statement of reasonableness. But you can't just say it's reasonable. The record has to indicate and have evidence, of reasonableness. And our courts have identified 4 factors that are to be considered when making that determination. And interesting to me, within the book, many of the cases that deal with rezoning, spot zoning, are Union County cases. The first thing, the rezone must be made in accordance with the comprehensive plan. The second one is the public hearing that's held in accordance with it must reflect legitimate factors for the different zoning treatment. For instance, does it have different physical characteristics? Is it in harmony with surrounding properties? Does it have compatible land uses? Or is it compatible with surrounding other land use plans like Monroe? The third one is who benefits and who is harmed by the rezone, and the relative magnitude of each. And they were very careful to state that just because there may be a substantial benefit to the owner of the property, that doesn't offset harm to surrounding properties. And the fourth one was the proposed zoning compared to the current zoning of the surrounding properties. Not my rules, the court's rules. And so I listened to the testimony that was given, to the hearing, to the comments that everybody made, even comments made here tonight. And I watched the planning board's comments, and went back through these 4 factors to see if there was anything offered on the record that would meet the reasonableness established by the courts. Well, the county's just adopted a new comprehensive plan last October. It was some 6 years in the making. The bypass existed at the time it was done, and it identifies that property and the surrounding area as low density residential. In fact, it's always identified that property as low density residential. It's never been changed. It wasn't changed when they knew the bypass was coming in. So there's a plan, so it doesn't meet that test. As to different zoning treatment because of characteristics based on the land. I didn't hear any testimony or evidence or comments made about any special characteristics of the property, making this property more suitable for industrial zoning. I actually heard evidence to the contrary, that it was a very susceptible piece of property that was in the overlay district for the water supply for Monroe, and Monroe offering a letter to the same, saying that they didn't think it should be rezoned for that purpose. All the properties contiguous to this property are zoned low-density residential. There are no utilities to the site. And while I did hear the applicant state that that was a good thing because they didn't need any utilities, the fact is when you rezone a piece of property, not just a spot zoning, but any zoning, you're required to look at every use allowable in the zoning. And we're not, and our land ordinance specifically states that we're not allowed to look at specific uses. And while I heard benefits taking trucks off the road, because they could potentially drive right onto the bypass, although the trucks bringing the aggregate to the site are still going to be on the road, and the benefits of added economic value and things, road improvements, they were all indicative to a specific use. I never heard any evidence as to a benefit of it being zoned industrial. I heard it would create jobs. Well, a parking lot is a use within the light industrial, and last time I checked, that didn't create any jobs. A landfill could be there. I mean, there are lots of things that can go there. So the only evidence that was given as far as benefit was to the specific use, and there's no way that this board can hold that property owner to that use. One of the cases I mentioned earlier involving Union County was cited as an example of illegal zoning. And there was an 11.4 acre parcel that was seeking a rezone from residential to light industrial. And it was overturned because there were no special features on the parcel that made it any more suitable for a rezone to a light industrial than any of the properties around it. It's not compatible with our county land use plan, as stated by the planning director, nor is it compatible with Monroe's land use plan, as stated in their letter. As far as benefit and harm, in Godfrey versus Union County, the property owner wanted to rezone to low-density residential. That was found to be illegal spot zoning because the court ruled that the intent and purpose was to accommodate the owner's planned use of the site. We're in a situation, like I said, the only evidence we heard was about exactly what this person, the property owner, planned to use the site for. Not only are they planning to use the site for that, they're currently using the site for that. And it's very clear that that is a huge benefit to the owner, but I haven't heard any benefit as to the industrial zoning to the rest of the community. In fact, if you zone that one industrial and then you start zoning the rest of them industrial, those people are going to be paying taxes based on an industrial zoned parcel. And I don't know if any of them are in the farm deferral program, but if they are, I would imagine that's going to cause an uproar as well. So the proposed zoning, the surrounding properties again are all residential. There aren't any uses like this around there. There's a church, there are farms, there are people living there. So in the record, I see no evidence of benefit. The staff found no favorable characteristics for the rezoning, not just against and for, but no favorable characteristics. Specifically, doesn't conform to our plan. It's an environmentally sensitive area. It's predominantly RA40. There are no utilities available. It doesn't conform with the surrounding municipality adopted plans. There was no statement of reasonable that I saw given or made by the planning board. One adjacent property owner is on the record as being against the rezone. Another property owner is only for the rezone if the use is temporary, which indicates to me he doesn't want it to be industrial either. He's just okay with them using for what they've been using it for, and then he wants them to go away. And the city of Monroe is not in favor. I heard something to the effect that, well, there were no complaints about the current operation, so obviously it wouldn't be a big deal for you to rezone it. But, you know, there are lots of times when people don't want to complain. And I would imagine that if there's an operation going on to the extent of this one, that, especially with a company that's known here, that perhaps people thought that they were doing something they were allowed to do, and who, you know, what's it to them to complain? So just because no complaints were made, or nobody found out about it, or didn't realize what they were doing they shouldn't have been doing, I don't think is a reason to say, well, then it won't have any adverse impact. So, based on the record, and if this gets challenged, that's what the court's gonna look at. I'd like somebody to show me where the reasonableness, the evidence in the record was given, that it meets that standard, because I don't see it.
Comments? Todd?
As was mentioned earlier, that our planning staff, with our planning staff and how they've looked at this rezoning, they're allowed 0 variance when they're reviewing a parcel for rezoning. They have basically what would be like a scorecard that they may simply use to measure this project against. And that's the same for all projects, regardless of the variance between the projects. And this scorecard is heavily weighted on our land use plan. A plan that, in my opinion, leaves a lot to be desired in the way of jobs and increasing commercial tax base, especially along the bypass. This board voted unanimously to start small area planning to overlay this plan because of its major shortcomings. Our planning board recommended this project for rezoning unanimously. They received a lot more in-depth information and have had a lot more input on this issue, as well as fielding public input. Now, the reason that I tell you that the planning board voted unanimously, and why that's so important, is that half of that board was appointed by the previous Board of Commissioners, and half of that board was appointed by the current Board of Commissioners. So therefore, you have a unanimous vote from a board that's a cross-section of 2 boards of commissioners. In terms of public opinion, many folks have spoken in favor of this rezoning. Also, the organization that would be most greatly affected negatively is Lee Park Baptist. And they've actually spoken in favor of this, and that church represents over 1,000 people. To my knowledge, only 2 have spoken against, one of which is the city of Monroe, in which we received a letter asking us not to approve, citing concerns with the watershed. This letter was issued prior to N.C. Dinger's approval of the rezoning and approval of that site. Now, with this approval in-house, Monroe would probably not have cited that as a reason, therefore not issuing the letter. The other individual, which is one of the only other objections that we've received, based on the information I've been able to gather, there may be personality conflicts between this individual and the current parcel owner. In addition, that individual's parcel is already zoned light industrial on half of it, and the other half is residential. But when he sold his parcel or a piece of land to Lee Park, he required that in the deed it state that should he decide to change the remaining portion of that to light industrial, they could not contest or object. Now, in terms of the location of the property, I would hope that most commissioners or all commissioners before voting have had a chance to go out to actually drive to this site. I drive by it often, so let me just mention a few businesses that you pass or a few of the neighbors of this parcel as you drive to and from this site. Caterpillar Plant, Electrical Distributors, Wood Forest, Boatwright Company, Boswell Company, Terminex, RCS Septic Service, Archetype Builders, a Wrecker Service, Poplin and Son Machine Shop, the stockyard, and the Windsor Windows and Doors plant, an actual full industrial plant. Monroe has incorporated in some of that area, and it has that area as general industrial. Also, what's important about this location of this property is that it's right beside the bypass. BOVA would have direct access to the Monroe bypass, and since they were awarded the contract, this is very important because of the safety and security that one of the speakers tonight spoke about. Many times we hear of or see folks that are greatly concerned about the safety of our roads. The number of large trucks that will be on the roads while they are building this bypass will be unbelievable. This project can remove a large amount of those vehicles from the road and also prevent damage to the existing roads. Our job is to keep citizens safe, and I think this project does just that. In terms of your commercial tax base, as most of you are aware, we are extremely top-heavy and rely heavily on the residential tax burden, where our citizens hold most of the tax weight of our county. Wayne University did a study for the Chamber of Commerce, and as a county, we were basically given two options: grow commercially or raise taxes. I'm going to choose to grow commercially in the areas of the county that want to grow commercially. Remember also, this project does not require additional water and sewer, nor does this project put a burden on our school system. That is a win-win-win situation. And lastly, jobs. Back during the campaign, one of my competitors gave me the nickname of the job czar. Now, I always called him the tax collector, so we kind of went back and forth on that. But the only issue that I had with the nickname was that a czar insinuated that government created the jobs. He stated to me, if you're a conservative, you know that government doesn't create jobs. So how are you going to bring jobs to the county? Which is a great question. My answer to that is, and it was, and it still is today, I'm going to get government out of the way. Well, tonight, this board has that opportunity to vote to get government out of the way. This vote tonight represents 400 jobs. So as the chairman asked, is that we vote on the merits of this policy, or of this project. I'll list the merits in brief. Voted unanimous by the planning board. Only one landowner against. Light industrial and general industrial is all around. Many voices of support. This keeps the roads safer for our citizens. It grows the tax base for the commercial side. There's no water and sewer needed. There's no burden on the schools. It brings 400 jobs to Union County. And for these many reasons, this is a very reasonable rezoning, and I support this project because it is ultimately the right thing to do.
Additional comments, discussion? Tracy?
I'd just like to reiterate that I'm not going to argue with what you perceive to be the benefits. The problem is, those are use-specific benefits. And our land use ordinance specifically states that you cannot look at a specific use when deciding the merits of a rezone. And my question to the board was, where is the evidence for the zoning itself? Not the project, not the use, not this company, not what they're doing, but for the rezone. And everything I heard was 400 jobs. Well, that's indicative to the use. Taking trucks off the road, that's indicative to the use. Everything that you stated were indicative to the use, and in the event we get challenged on this, that's exactly how these other cases were overturned, because of that kind of thing. And I would submit to you that the jobs it creates, first of all, even by admission of the applicant, they're temporary, and they were not created, or will not be created by this rezone. They were created by the bypass and the Turnpike Authority awarding the contract.
further discussion?
I appreciate the opportunity to speak just for a moment on the project. I don't know that I can follow up much more to the comments that have been made, other than to say that there's really three premises in which I ran for this office. Number one, to reduce the cost of government. Number two, to do the best we could in the creation of jobs. And number three, to protect and promote the quality of life in which your family and my family call home. And we've heard, I think, over and over from that podium, reasons why this project should be approved based on the merits. The land use plan is simply a guide that we use to be able to determine how we should use our property. And yes, it is residential. Commissioner Keeler is absolutely correct in that. But I don't know, those of you gathered here tonight may be smarter than I, but I certainly don't want to live in an exchange on a major highway. And I don't think most people do. We've got an opportunity to create jobs, and to believe that there's no jobs to be created, you tell me how a road gets laid without workers. I don't quite understand it. And not only that, then where do they eat? We heard a speaker tonight say it's the residual jobs that we get from the creation of one job that drives a community. And in the tough economic times that we find ourselves, we have to be able to respond to jobs. We've not heard one request from that podium in this particular matter asking for any kind of incentives, asking for any kind of water, any kind of sewer, and that's much different than any other commercial project that we have coming before us. In addition to that, we don't see any additional burdens put on our schools. We hear oftentimes that the funding for our schools, well, how do we fix that? And I think Commissioner Johnson said it well. We either build the commercial base or raise the taxes. This commissioner will not vote for your taxes to be raised. We've got no other choice but to respond to any time we've got someone who's willing to expand or start a business in these tough economic times. I think it's prudent to be able to respond to that and do so in a timely way. A 6-0 vote on the planning board is something that we can't overlook. The safety of our citizens is something we can't overlook. The fact that the closest neighbor to this project is a church and they give their approval, and yet we have one commissioner wanting to cite harm. I don't believe a church of over 1,000 members can be that dismayed. It is therefore my decision, Mr. Chairman, to support this project, and with that, I'll call the question.
Thomas called a question. All those in favor, say aye. Aye. Opposed?
Nay. I hate to do this to you, but as part of your motion, you need to include approval of the applicable consistency statement.
Okay.
And that was included as part of your motion. And
I will do that. Thank you. Here we have a motion to approve the petition and the applicable consistency statement. All those in favor say aye. Aye. Opposed?
Hey.